Yes, sorry.
We do it in light of Pitalia and other and NHS England.
Sorry to keep you waiting. We were getting supplied with up-to-date whitebooks.
My lady, my lords, this is the hearing of an appeal against the order of His Honour Judge Pearce made on the 24th of June 2022, whereby he dismissed the appellant's appeal against an earlier decision in the Manchester County Court of District Judge Matharu on the 27th of August 2021. I represent the appellants. Learned friend Mr. Ray represents the respondent. Lord Justice Stuart Smith granted permission to appeal on the 27th of February this year, grounds 1, 2, 3 and 5. I'm not asking the court to turn up the bundle at this stage, but for the note, the orders which the appellants seek include a declaration that the court has and should exercise jurisdiction to try the substantive claims. And that's at pages 26 and 27 of the core bundle. The substantive proceedings arise out of a commercial contract between the appellant general practitioners and NHS England. And
It's up to you, Mr. Trotman. If there are things that you particularly want to draw our attention to, you must, but we are very familiar with the background. So I don't think, as I say, if there's some particular point you want to make, of course do, but no need to sort of walk us gradually up to the points.
My Lord, I'm very grateful for that indication. I had intended, I must say, to go through the procedural chronology, but I'm grateful for that indication.
Well, as I say, if for some forensic reason you feel you ought to, that's fine. But if it's just to make sure we know it all, I think we do, and it'll soon become clear if we don't from our questions.
Well, my Lord, I think all I will do at this stage is, within the chronology, simply ask the court to notice a letter in the supplementary bundle at page 105. This is a letter I will be returning to, but as we are looking at matters of chronology at this stage, it's perhaps relevant to note it now. It's a letter from the respondent's solicitors, who I was going to refer to as Hill Dickinson.
What else would I refer to them as? You mean you're going to leave off the LLP? Very sloppy. Yes, sorry.
Supplementary bundle 105. Yes. Dated 16th January 2020, making points about the original sealed claim form, which I'm not going to go through now. It's the final paragraph on page 105 that I shall be returning to. In the circumstances we presently intend to apply to strike out the claim form. We intend to do so promptly. Before doing so, we invite your observation. As I say, that will achieve significance later in the submissions. My Lord, I was also going to go to the hearing before District Judge Matharu, but I think from the indication given I don't need to do that. What I think I would like to do, however, is just to look at some parts of the decision of His Honour Judge Pearce, if I may.
That certainly, yes.
And if we can look together in the core bundle at page 51. No, I don't mean that. Page 123, sorry.
Yes.
At paragraph 51, this is the first of the substantive findings of His Honour Judge Pearce. A defendant who files an acknowledgement of service is to be treated as accepting of the court's jurisdiction to try the claim, if he does not also apply under CPR 11.1 for an order declaring that the court has no jurisdiction or that the court should not exercise any jurisdiction which it may have. And the judge is effectively applying, I would argue, Hodinott and Persimmon Holmes. The learned judge then rejected the proposition that Hoddinott had been impliedly overruled. And that's the second key finding, which is at page 125, paragraph 59. Thirdly, contrary to the overall conclusion of the district judge about submission to jurisdiction, the respondent was to be treated as having accepted the jurisdiction of the court unless it had made the requisite application under CPR 11.1. And we can see that finding at paragraph 64 on page 126. And finally, the learned judge rejected the respondent's interpretation of Kane against Advertiser, case from 2019, allowing the respondent said, allowing it to reread its 24th January 2020 application, because there was never any reference in the application to CPR Part 11. And we can see the judge's finding there at paragraph 69 on page 127. And so the sole substantive ground of success for the respondent before the learned judge was an argument which the court accepted on the face of the decision was a new exercise of discretion. And that's at paragraph 70 on page 127. And the gist of the court's reasoning was to note the timing of the respondent's application, the issue of standards of procedural rigour, and to conclude that there had been a procedural error which the court was able to rectify under CPR 3.10. That is a somewhat rapid summary of paragraphs 70 to 74 and also paragraph 75 letter C on page 129. So I'll turn to the first ground of appeal, that is that CPR 3.10 should not be used to achieve something that is prohibited, and the full ground is that the learned judge erred in law when he deployed his general powers under CPR 3.10 to achieve an outcome which was prohibited by a more specific provision of the CPR, namely CPR Part 11. And the first relevant authority is Venos against Marks and Spencer plc, which we can find in the final authorities bundle beginning at page 46.
Yes, we find it there in an unreported version. It is in fact a reported case. I don't know how that happened. It's reported in the All Englands, but don't worry about that. Just so that I don't
All England
mention it twice. The Steele and Mooney, likewise, we only have it as a transcript, but is reported in the weeklies. So not the end of the world, but it does help. These are not just stickler points. It helps us to be able to use the head note. And
thank you, my lord.
however, we will read it in whichever version you've got, which I assume is the transcript only.
It is. This concerned a palate injury in a workshop in May 1996. In May 1999, the claim form was issued and the 4-month validity period expired on the 20th of September 1999. On the 27th of September, the claimant's solicitors posted to the defendant's solicitors the claim form and particulars of the claim. Deemed service was the 29th of September, which was 9 days late. On the 21st of October, the claimant applied to extend time to serve the claim form, but the district judge dismissed that application and set aside service of the claim form. A first appeal was unsuccessful and the Court of Appeal dismissed a further appeal. In essence, it was held that the general words of CPR 3.10 could not extend to enable the court to do what Rule 7.63 specifically forbade, and we can pick the decision up, if I can put it like that, at paragraph 20
Yes.
on page 51 of the final authorities bundle. And about 5 lines into paragraph 20, the court said that the general words of 3.10 cannot extend to enable the court to do what Rule 7.63 specifically forbids, nor to extend time when the specific provision of the rules which enables extensions of time specifically does not extend to making this extension of time. What Mr. Vinos in substance needs is an extension of time. Calling it correcting an error does not change its substance. Interpretation to achieve the overriding objective does not enable the court to say that provisions which are quite plain mean what they do not mean, nor that the plain meaning should be ignored. If one goes over the page, page 52, and continues 3 lines in, Rule 3.10 concerns correcting errors which the parties have made, but it does not by itself contribute to the interpretation of other explicit rules. I rely on that passage. I'm not going to read it out in full, but I also rely on the further observations of Lord Justice Peter Gibson, which we can see at paragraph 27 on Authorities Bundle, page 54. A principle of construction is that general words do not derogate from specific words. Where there is an unqualified specific provision, a general provision is not to be taken to override that specific provision. Rule 7.6 is a specific subcode dealing with the extension of time in all cases where the time limits in Rule 7.5 have not been or are likely not to be met. The subcode sets out in some detail what the claimant must do if he wants an extension of time, and the circumstances in which the court may exercise the discretion conferred on it to extend time. Rule 7.63. That the circumstances specified in subparagraphs A, B and C of Rule 7.63 are the sole relevant conditions for the discretion to be exercisable seems to me to be made crystal clear by the words only if. It is plain that the general power in paragraph 3.12a to extend time cannot override 7.6. Nor, in my judgment, could the general power in Rule 3.10 to remedy a failure to comply with a rule be pressed into service to perform the like function of, in effect, extending time, even though Rule 3.10 differs from 3.12 in not having the wording to the effect of except where the rules provide otherwise. That is too slight an indication to make Rule 3.10 override the unambiguous and restrictive conditions of Rule 7.63. And as the court knows, my point, or the appellant's point here, is that CPR Rule 11 has all the features of a similar type of subcode. My lady and my lords, I'll turn to Steele and Mooney, which is the next case in the bundle, beginning at page 55, noting the comments made by the court. This concerned an alleged negligent hysterectomy in May 2020. The claim form was issued in May 2003, and on the 21st of July 2003, the claimant's solicitor proposed a draft consent order, which is helpfully set out in full in paragraph 3 on page 56, for extensions of time. Paragraph 1 referred to the particulars of claim only. Paragraph 2 of the consent order included reference to the claim form. When a month later the claimant's solicitor applied to extend time for service of the particulars of claim, her reference to the claim form was omitted by mistake. a deputy district judge extended time to serve the particulars of claim in mid-August 2003, and there was a further application to extend time for service, again only of the particulars of claim, which resulted in a further such order in mid-December 2003. In February 2004, the claimant's solicitor applied to rectify previous orders under CPR 3.10 to include a reference to the claim form. In March 2004, a deputy district judge granted rectification of the previous orders, but a circuit judge reversed that decision in April 2004, finding that CPR 3.10 was not applicable. In the Court of Appeal, the defendant objected that allowing rectification of orders would allow the correction of any application, and to take an absurd example, say for disclosure of documents made in the 4-month period by substituting an extension of time for service of the claim form. The court rejected that, as in such a case, the error would simply lie in the fact that, as in Venus, the claimant had failed to apply for an extension of time within the specified period. And we can find that at paragraph 27 on page 62. The error would not lie.
How much? Sorry, how much were you proposing to read? Would it be more efficient for us to read it ourselves? Or
I think it might be more efficient if the court simply.
Yes. Is it the whole of the sideline passage?
Yes. Yes, it is.
Yes.
Well,
Yes.
Before we move on, there are two observations I'd make about the sideline passage. First, in this case, a distinction began to evolve between a difference between making an application which contains an error and erroneously not making an application at all. It has to be said that distinction has followed its way through the authorities, but since the case of Ideal, it is no longer considered to be a useful touchstone in the application of 3.10.
Well, it may be less useful, but in a way that doesn't help you, because we'll come to Ideal in a moment, so perhaps I'm anticipating it. But the point is that it was simply an illustration of why, in that particular case, it didn't infringe or it was to be distinguished from Venus. But the more general message that comes through all these authorities is you've got to characterise the error correctly.
Yes.
To see what it is you're attempting to do and whether that's something for which there is a separate code.
Respectfully.
So I don't really think that particular wording, I agree, isn't of general application, but the principle which it exemplifies remains in rude health, doesn't it?
Oh, yes.
Yeah.
Yes.
Sorry. Anyway, sorry. That was the first of the 2 points you wanted to make.
Yes, the second of the points is in paragraph 28, where 5 lines in, the court said, our reference to what was intended is not to Miss Watkins' subjective state of mind, it is to what she must be taken to have intended on an objective assessment of the terms in which the applications were expressed. And again, that may also help us later on in interpreting some of the cases and the applications. application or the arguments that the appellants made. My lady, my lords, I'm going to pass fairly rapidly over the next section of my skeleton at paragraph 11, because there has been a group of authorities which appeared to adopt a more expansive approach to the court's powers under CPR 3.10. Phillips and Symes, Integral Petroleum, Bank of Baroda and Dory Acquisitions. I don't think it's necessary to notice them in any great detail.
Quite apart from anything else, you haven't put them in the bundles.
They're not in the bundle either.
No, but that's fine. I agree, because we've got the last word in ideal, haven't we?
We have. But before we reach that, my lord, may I turn to Barton and Wright?
Yes, certainly.
Which is at page 219 of the authorities bundle. A litigant in person in February 2013 issued a claim form for professional negligence against solicitors and elected to serve the claim form and particulars of claim himself. On the last day before expiry of the claim form, he emailed the defendant's solicitors, attaching the claim form and particulars of claim. He failed to obtain prior permission to serve by email. In this set of facts, the defendant served no acknowledgement of service, but said it would not accept service because the claim form had expired and the action was out of time. The claimant applied for retrospective validation of service under CPR 6.15. District judge refused. The appeal was dismissed. The Court of Appeal upheld the decision and the Supreme Court affirmed that decision. And if we start at paragraph 16 on page 228, Lord Sumption emphasised that it had never been enough that a defendant should be aware of the contents of an originating application such as the claim form. And he made the well-known remarks next to letter F on page 228. This is because a bright line rule is necessary in order to determine the exact point from which time runs for the taking of further steps or the entry of judgment in default of them. Service of the claim form within its period of validity may have significant implications for the operation of any relevant limitation period, as they do in this case. My lords, I refer to that case now because it seems to me that it was instrumental in causing a change of heart about CPR 3. Not a change of heart, perhaps a change of direction about CPR 3.10 in the next relevant authority, which is Piepenbrock, which is at page 265 of the authorities bundle. Decision of Mr. Justice Nicola.
I don't want to stop you taking us to Piepenbrock at all, if you want to, but Piepenbrock was approved, wasn't it, in ideal, and weren't all the relevant bits quoted? Perhaps they weren't, but no, sorry, I may be being do it your own way.
May I take the court through the facts of Piepenbrock, or shall I just go to the relevant bits?
Speaking for myself, it's the statement of principles by
yes,
Mr. Justice Nicola that you're no doubt relying on.
Well, yes.
So I wouldn't have thought it was necessary.
No. I mean, in essence, Piepenbrock was another case where the claim form was not properly served and expired before it had been properly served. But yes, the relevant passage is at page 287. And one can pick it up at paragraph 81, where Mr. Justice Nicola refers to Barton and to the a line of authorities that the comments as to whether CPR 3.10 can validate an error in serving this claim form are strictly obiter, And there is a consistent line of authority that suggests that CPR 3.10 cannot be used to rescue a claimant who, having failed to serve the claim form by a permitted method, cannot bring him herself within 7.6, 6.15 or 6.16. And then in paragraph 82, Mr. Justice Nicola says, "My conclusion is that CPR 3.10 cannot assist the claimant in this case. I consider that Barton is a clear statement of the underlying principles as to the importance of serving the claim form. CPR 3.10 was not referred to in Barton. Yet if the argument as to the width of the rule were correct, it would appear to have been an obvious solution to Mr. Barton's predicament. In my view, the analysis of Lord Sumption as to why CPR 3.9 easy naps would apply equally to 3.10. If CPR 3.10 is given an interpretation that permits the court retrospectively to validate service not in accordance with the CPR on the basis that there has been a failure to comply with a rule, that would make CPR 6.15 redundant. That would be a surprising result, as the terms of 6.15 are specific operation, whereas 3.10 is of general application. My lords and my lady, before we leave that sideline passage, I also note Roman 4 little b, the general language of Rule 3.10 cannot be used to achieve something that is prohibited under another rule. This is the principle established by Venus. The next case in the line of authorities is Serbian Orthodox Church, but again I'm going to pass over that, and it isn't in the bundle, and move straight to Ideal, which is at page 289, Ideal Shopping Direct Limited against MasterCard and Visa Europe. The claimants issued a number of claims against MasterCard and Visa using an Electronic Working Party Scheme, or CE5. They prepared them for service, and the 17th of July 2020 was the deadline for service. In respect of at least 14 MasterCard claim forms, 12 only achieved acceptance, or sealing, as it were, under the scheme too late on Monday the 20th of July. So in default of receiving that acceptance, the claimant's solicitors decided on the 17th of July at 3 o'clock in the afternoon to serve unsealed amended claim forms under the scheme. Later on, towards the end of the month, end of July 2020, the claimant's solicitors served sealed claim forms on MasterCard and Visa, but this was out of time. The claimants applied for declarations that they had validly served claim forms before the 17th of July, alternatively an order under CPR 3.10b remedying the error of procedure. Their application was refused at first instance. What had happened was not an error of procedure which could be remedied under 3.10. And it was held on appeal that the claim form had to be sealed before it could be validly served, and by asking the court to make an order under 3.10, the claimants were in effect asking the court to treat service of an unsealed claim form as good service, or to extend time for service, two things which were impermissible, as 3.10 was being used to bypass 6.15 and CPR 7.63. The point about taking no action or acting defectively emerged in Ideal Shopping, and we can find it at paragraph 68 on page 307. And counsel for the claimants in that case, Ms. Smith, submitted that the case law drew a distinction between, on the one hand, taking a procedural step defectively, and on the other, omitting to take that step at all, or performing a step in proceedings which is directly contrary to the rule. 3.10 can be used in the former, but not the latter. She submitted this case further to the former. And the same point appears at paragraph 77 on page 310. In other words, what the court was being asked to do, this is by reference to Steele and Mooney, was not to use Rule 3.10 to extend time for service otherwise than under Rule 7.6, but to correct an error in the application and the orders made. Ms. Smith submitted that the present case was on all fours. She meant on all fours with Steele and Mooney, on the basis that the amended claim form served on the 17th of July should have borne a seal. That was a failure to comply with the practice direction of the electronic scheme, which was the error of procedure akin to making an application which contained an error in Steele and Mooney. The court rejected that argument, and I'm going to, if I may, pick out 7 short passages which I hope encompass the reasoning of the court. And the first is on page 327, paragraph 145. This concerned what is an error. And the court said it's important to analyse correctly what is the error of procedure which the claimants are asking the court to remedy. They are in substance asking the court to treat the service of unsealed amended claim forms as good service and dispense with the requirement for any further service. Those are matters which rules 6.15 and 6.16, to which rules 1.5 and 1.6 are applicable. And yet the claimant's applications under those provisions were refused. The second of the passages is in the next paragraph 146. It follows that the claimants are asking the court to do the very thing which Venus and the line of authority which follows it does not permit. The general provision in Rule 3.10 cannot be used to override a specific provision, here Rule 6.15, 6.16. The claimants could not satisfy the good reason or exceptional circumstances criteria under those two rules, and they are not permitted to use Rule 3.10 to bypass the requirements of those specific provisions. The third passage is over the page at paragraph 148 on page 328. Whilst it is correct that Steele and Mooney draws a distinction at paragraph 27 between making an application which contains an error and not making an application at all, it seems to me that this is not saying that in the former case Rule 3.10 will be available, even if the remedying of the error will involve bypassing a specific rule about service. It is simply making the point that because the claimant there had sought extensions at the time, that the order may contain an error, the remedying of the error did not circumvent the prohibition in Rule 7.63. The fourth passage I rely on is at the bottom of the page 328 in paragraph 149, referring to the case of Bank of Baroda. The judge there, it was said, sought to draw a distinction between where a procedural step was taken defectively rather than omitted or performed directly contrary to a rule. Ms. Smith seeks to draw the same distinction. I do not consider that this is a valid distinction. Over the page, at the top of page 329, the court said, if the remedying of a procedural step taken defectively would involve bypassing a specific provision, such as Rules 7.6 or 6.15, it would still fall foul of the principles established by Venus. And although I haven't referred to it yet, and it isn't in the bundle, the case of Elms, it was treated as an example of that principle. The sixth passage I rely on is in the next paragraph, 150, on page 329. Thus, in the present case, it is no answer for Ms. Smith to rely upon the distinctions she seeks to draw and to categorise this as a case where the claimants did take a procedural step, but did so defectively. The remedying of that error under Rule 3.10 would still involve bypassing Rules 6.15, 6.16 and 7.63, and is thus not permissible. The provisions on service of originating process in rules such as 6.15, 6.16 and 7.6 form part of what Peter Gibson, LJ, described in Venus of paragraph 27 as a specific subcode dealing with service and cannot be overridden or bypassed by the general power in Rule 3.10. And in a very similar vein, about 5 lines into paragraph 151 on the same page, however wide and beneficial a scope Rule 3.10 is to be given, in other circumstances than the present, it cannot be used to remedy a defect in service which is incapable of being remedied by the more specific rules. Here, 6.15, 6.16 and 7.63. Again, it's the same point about bypassing. The appellants extract the following principles from these authorities. Firstly, whilst the line of cases...
Sorry, just so that I know whether to take a note. Are these the points you make in
paragraph 20 of my skeleton.
Yes, okay, that's fine, thank you.
So we extract the following principles. Whilst the line of cases culminating in ideal mainly concern defects in issue or service of the claim form or particulars of claim, a general principle can be derived from them which is wide enough to have application to the index facts and to CPR Part 11. My lord, the claimant's skeleton, paragraph 20, it's a page...
I have it, if you would.
Page 62.
Yes.
Of the Corban. Yes. The principle is wide enough to have application to the index facts and to CPR Part 11. The principle is that the general discretionary power in Rule 3.10 should not be used if its effect would be to override more specific provisions in another part of the CPR. Particular language used may help to identify what is a more specific provision. Rules may provide restrictive qualifications as to the exercise of that discretion, such as the phrase good reason in 6.15, exceptional circumstances in 6.16, or all reasonable steps taken to comply in 7.63. But a more specific...
Well, sorry, perhaps I've read ahead, but is that really right that the provisions of CPR 11 are of the same character as the codes or subcodes identified in CPR 6 and CPR 7, which the case law is about? CPR 11 doesn't impose a substantive mandatory conditions for getting the declaration which you're seeking, such as you must do it, whatever the criteria are, must be exceptional, and so forth. It simply offers a procedural route for resolving a issue about the whether the court has jurisdiction. So it's not really on all fours, is it, with the sort of situations that are being considered in the case law?
My lord, the best response I can give to that is to refer the court to paragraph 22 of my skeleton, where I have tried to portray CPR Part 11. Portray is not the right word. I've said it is a more specific provision because of its close interlocking format. It does contain peremptory terms, and it imports expressly a form of waiver, which is a slightly unusual thing to do. And I've set out in paragraph 22 three examples. CPR 11 allows for an application for an order declaring the court has no jurisdiction, but only if the defendant first files an acknowledgement of service, the consequences which are specifically ring-fenced in 11.5. Within a specified period, 14 days, as a matter of obligation, the index application in relation to jurisdiction must be made, which must be supported by evidence. If a defendant files an acknowledgement of service but does not make an application, such a defendant is to be treated as having accepted that the court has jurisdiction to try the claim. My Lord,
could I go back right to the start, Mr. Trotman? The very first document you showed us, the letter from Hill Dickinson.
Yes.
Can we look at it, please? Supplementary bundle, page 105.
Yes.
Suppose that the last paragraph on page 105 were not there. So that they just said, as they do in the first 4 paragraphs, the claim form has not been, cannot now be served.
Yes.
And instead of the final paragraph, they'd simply said, in these circumstances, we consider that this case is at an end and we are filing our papers, yours faithfully.
Yes.
What would your clients have done then?
Well, my Lord, this picks up an argument that my learned friend has made in his skeleton, that one of the options is doing nothing.
Yes.
But having considered that, I would argue that there are some serious problems with that point, because we can go back to the case of Ronex and Lang in 1983. The limitation bars the remedy, not the right.
Mm-hmm.
So it is necessary for a defendant to assert a limitation defence. And
No, but forgive me, it's not a limitation defence. Hill Dickinson are just saying, your claim form has expired. Therefore, you're stuffed, yours faithfully.
my Lord, there is another argument, answer to this response. I realise my learned friend takes the point that in CPR 11.1 the word may is used, may apply, and that's the point your Lordship is, I think, making. But if we look together at part 10, that's at page 405, CPR 10.1.
Oh, we're looking at the white book now.
Yes.
Which page?
Page 405. There is a mandatory regime here under 10.1 in brackets 3. A defendant must file an acknowledgement of service if they are unable to file a defence or they wish to dispute the court's jurisdiction.
Mm-hmm.
So, again, I have some difficulty with respect with my learned friend's do nothing argument.
Well, can we just pause there? If someone has served a defective claim form, I know as soon as you start talking about nullities, you get into complications, but can we just use the word nullity as a shorthand? It's effectively a nullity. One thing you can do, certainly, is, so that everyone knows where they are, make an application under Part 11.
Yeah.
But do you have to?
I believe you do.
If it's a nullity, it's a nullity. Why do you need to get the court to say so? Is it disputing the court's jurisdiction? It's an odd phrase.
My Lord, one answer to that point is provided in the case of ACCAS and Adepta, where that very question arose.
Ah, well, thank you. Let's have a look.
If we look together at the facts of that case,
It's page 114, Mr. Shotman.
thank you, my lady. This was a case of a negligent failure to serve a claim form in time, and the main issue here was whether or not it would have been an abusive process to commence a further set of proceedings. But in the course of considering that issue, if we turn to paragraph 17 on page 124, the court said that on the facts of ACCAS, it was agreed that if the claimant were not permitted to dispense with service, the defendant's application to set aside the claim form in its service had to succeed. In the event Deputy District Judge Mashida's order was to set aside. In Dixie, it similarly does not appear what application the defendant made. In these appeals, Mr. Rowley submitted that the correct application is under 3.42c, to strike out a statement of case if it appears to the court that there has been a failure to comply with a rule, practice, direction, or order. He accepted that the correct application was not within 3.42b. I'm not going to read the rest. It's this case where an error was unfortunately made because...
Sorry, you say you don't want to read the rest. I'm sure you're right, but I haven't looked at this authority so far.
Sorry.
He sets out what the two case answers are there, but how does he resolve it?
Well, respectfully, my Lord, before we get to the resolution, the court made an error because it said in the final paragraph of paragraph 17, the difficulty with Mr. Rowley's suggestion is that CPR 3.4 applies in terms to a statement of case rather than to a claim form. In fact, that isn't correct. 3.4 does apply to a claim form. But my argument is that really that error is neither here nor there, because in the next paragraph, Lord Justice Ricks said, it appears from Hodinott and Persimmon Holmes that definitive support is there to be found for the CPR Rule 11 route, as Mr. Ulstein brought to our attention in his reply.
But is that, again, I haven't read it, is Lord Justice Ricks simply saying it appears there's definitive support, but then goes on to say maybe it isn't, or are we to read that as accepting it?
I'm sorry, my Lord, continuing. On that basis, a defendant who is served out of time has to file an acknowledgement of service and bring his application within 14 days. Otherwise, he is to be treated as having accepted that the court has jurisdiction to try the claim. What happened in Hodinott's case was that the defendant successfully applied to set aside the claimant's ex parte success in obtaining an extension of time for serving his claim form, but in the meantime, it had acknowledged service and failed to exercise.
Well, I can see that. I still try. It may be clear from the context. It's not clear that Lord Justice Ricks is actually saying that is right. Maybe he is.
Respectfully, my Lord, I think he is.
Yes. No. I'm just trying to work it out. I'm sure you're right. And I did read Hodinot. They didn't directly address this. They did. That's right. It's at paragraph 21.
That's correct, my lord,
About
yes.
what constitutes jurisdiction. So perhaps that's the answer.
My lord, if I just pick it up in my notes. Yes, if we look together at Hodinot,
Yes.
the claim form was issued in May 2006, and in September 2006, the claimant applied without notice under CPR 7.62 to extend time for service of the claim form to the 22nd November 06. On the 13th of September 06, District Judge Rowe extended time for service to the 22nd of November 06. On the 14th of September, the claim form was enclosed copy information only. On the 22nd of September 2006, time for service of the claim form expired, subject to extension. On the 2nd of October 2006, and the key point here is that is before making any acknowledgement of service. On the 2nd of October 2006, the defendant applied to set aside the order of the 13th of September. On the 21st of November 2006, the claimant served the particulars of claim, and on the 28th of November, the defendant filed an acknowledgement of service, ticking intend defend all of claim, not ticking intend contest jurisdiction, which is the same in the index case. On the 21st of December 2006, District Judge Daniel set aside the order for an extension and struck out the claim. There's no reason why the claim form could not be served. It was ridiculous to require the defendant to make a further application under Part 11. He accepted the applicability of Part 11, but it wasn't necessary in the circumstances, the district judge said, for there to be a Part 11 application. However, the disagreements of the Court of Appeal with that line of thinking are significant, and that we can pick it up at page 92 in the authorities bundle. The first issue raised by the defendant is an argument that the court already had jurisdiction, but that was disposed of at paragraph 26 on the bottom, at the bottom of the page. Paragraph 1 of CPR 11 permits the defendant to apply to the court for an order declaring that the court has no jurisdiction to try the claim, or that the jurisdiction should not be exercised. Paragraph 2 provides that the defendant who wishes to make such an application must first file an acknowledgement of service. Paragraph 4 provides that an application under 11 must be made within 14 days after filing an acknowledgement of service. Paragraph 5 provides that if the defendant files an acknowledgement of service and does not make an application, he is to be treated as having accepted that the court has jurisdiction. And in our judgment, the meaning of paragraph 5 is clear and unqualified. If the conditions stated in subparagraphs A and B are satisfied, then the defendant is treated as having accepted that the court has jurisdiction to try the claim. The conditions include that the defendant does not make an application for an order pursuant to CPR Rule 11 within 14 days after filing an acknowledgement of service. An application to set aside an order extending the time for service made before the filing of an acknowledgement of service is not an application under CPR 11, nor is it an application made within 14 days after the filing of the acknowledgement of service. The judge rightly did not hold that the application to set aside the order extending time for service was an application under CPR 11, Rather, he said that the earlier application to set aside the order rendered it unnecessary to make an application under CPR Rule 11. But in our judgment, there is no warrant for holding that if an application is made before the filing of an acknowledgement of service to set aside an order extending the time for service. This has the effect of disapplying the requirement for an application under CPR Rule 11. The last words I submit are very important here. There is no such express disapplication, nor does one arise by necessary implication. My lords, it may be a useful way of interrogating that decision to look briefly at what my learned friend says in his own skeleton argument, which I think we can find. Paragraph
Isn't it relevant that in the Hodinot case, the acknowledgement of service which was filed said that the defendant did not intend to contest jurisdiction?
My lord, I don't believe that was the decisive factor in the case. However, if it was the decisive factor in the case, in our own case, the acknowledgement of service is in the same form.
Not saying we do not intend to contest jurisdiction.
Yes. In the index case, the acknowledgement of service says, I intend to defend. So,
no, that's
that right?
That's different. Surely, can we look at the acknowledgement?
my lords, I fear that this particular document is not in the bundle.
It was ever thus, hundreds of pages, but not the one wants.
However, we are assisted by the decision of His Honour Judge Pearce itself, because he made a summary and.
Mr. Ray has
Just
asked.
before, we think it is in the bundle, but it's as an exhibit to Mr. Parker's first witness
Well,
statement.
just give us the
Trying to
reference.
locate where within that exhibit it is.
Well,
It,
show us the exhibits and then we'll no doubt it won't take long to find it.
The exhibit, the relevant witness statement is behind tab 7 of the supplementary bundle, and there are lengthy exhibits there.
Yes, I see. So, well, if they are in chronological order, which one would like to think they were, is it page... No.
There is an uncompleted version at page 72.
Yes, I saw that, but we want the completed version.
If we don't have the completed version, it may well be. My learned friend and I have both seen it. I think we can probably confirm what it can entail.
Well, sorry, let's just one thing at a time. Are you resigning, which you're perfectly entitled to, from your statement that it is actually in the exhibit? In which case we'll stop looking.
I think I may have been mistaken. In haste in seeing the response pack, the unsealed, uncompleted form appears twice.
Yeah, but that's not what we're interested in.
So my instructing solicitor says page 205, supplementary bundle.
Ah. Thank you.
There's also the covering letter that went with it at page 203.
Thank you. So he ticked, I intend to defend the claim. He didn't tick, I intend to contest jurisdiction. Yeah, well, that's what the judge says in the judgment, isn't it?
Yes.
So what? Sorry, before we get lost from how we started on all this, you say that where a defective claim form is served, certainly defective in the way we're concerned with here, whether because unsealed or because it's after the end of the 4 months. That goes to jurisdiction.
Yes.
And therefore you must file an acknowledgement of service under 10.3. And if people like me say that's a funny use of the term jurisdiction, you say Hodinot makes it clear it doesn't
The
work.
Hodinot, yes.
Okay.
Mr. Trotman, it's a slightly different point, but given that Hodinot is still open and in front of me,
Yes.
at paragraph 26,
Yes.
is it of note that about 4 lines down, it states that paragraph 1 permits a defendant to apply to the court for an order? There's nothing mandatory in that. It's permissive.
Again, my lady, this is a point that's been raised by my learned friend because of the use of the word may.
Yes. Well, may is the actual wording in 11.1, and that, it might be said, is picked up in paragraph 26, where it says paragraph 1 permits a defendant.
Yes.
One reflects the other.
My lady, there is, I would argue, an underlying rationale that means that CPR 11 is in fact the correct procedure, and it's because of the use of the expression in CPR 11 of set aside. And I argue that that is of fundamental importance in this case. There is a conceptual difference between setting aside and striking out. And in many ways, I would argue that that is the key to many of the points raised by my learned friend, which is the key to the argument, really, that I'm making this morning in the court. In order to illustrate that, may we turn to the case of Burns, where this point is really brought out. The court can find Burns at paragraph 66 of the bundle. The claim form was issued claiming contractual indemnity in December 2003. It was amended in 2004. There were unsuccessful attempts to serve in 2004. Deemed service took place in May 2004 on the defendant's solicitors. They acknowledged service. There was a consent order extending time for serving the defence. Those are the defendant's solicitors. Dawson's application to strike out the claim form having been served after it had expired. And the claimant applied for an extension of time to serve or dispense with service. And the claimant argued that the defendant had submitted to jurisdiction having failed to file a CPR 11.1 application within 14 days of acknowledgement of service. The extension of time for serving the defence did not, under the Part 11, have the effect of extending time to make an application, and the defendant was out of time to make its application under CPR 11.4. So those were findings mostly against the defendant, but at paragraph 42, on page 81, the learned judge recorded this. A remaining question is whether, as the defendant contends, his challenge to the service of the claim form is not a challenge to the jurisdiction of the court at all. It is a challenge which is not confined by CPR 11.5. It can be raised just as conveniently under CPR 3.4. That is very much echoes the point made by your ladyship, and echoes many of the points raised by my learned friend in his skeleton argument. But in my submission, the judge in this case made an extremely telling response, and this begins at paragraph 44 on the next page, page 82. 11.6 provides that the court may make an order under that rule setting aside the claim form or setting service aside. The power conferred by CPR 3.4 is to strike out a statement of case. According to the glossary to the CPR, setting aside involves the cancelling of a judgment or order or a step taken in the proceeding. Striking out means the court ordering written material to be deleted so that it may no longer be relied upon. These definitions, although only intended as a guide, illustrate that the power to strike out under CPR 3.4 is focused on the content of pleadings, whereas the power to set aside, wherever it is conferred by the rules, involves expunging of the step in question from the record of the proceeding. In practice, the consequences may be the same, since a statement of case includes a claim form, so the entire contents of the claim form may be.
I'm so sorry, I've been listening but not following. Where are you reading from?
This is, I'm now in the middle of paragraph 44.
44. Oh,
Sorry.
44. No.
On page 82.
Yeah.
In practice, the consequences may be the same, since a statement of case includes a claim form, and so the entire contents of a claim form may be struck out under CPR 3.4. But the purpose of CPR 3.4 is the same as its predecessor in the rules of the Supreme Court, Order 18, Rule 19. Order 18, Rule 19 applied to pleadings and endorsements on writ. These rules enable objectionable material in pleadings to be erased, with the consequence that a judgment on one or more issues may follow.
I'm so sorry. I'm still haven't got it.
Oh, I'm sorry.
Which page of which bundle?
I'm sorry, my lord. It's the Final Authorities bundle, page 82.
This is Judge Havelock Allen.
Oh, I'm so sorry.
Burns
Right.
Anderson.
Thank you very much indeed. Yeah, I will catch up now. Yeah, thank you. Keep going.
Yes.
I've got it now.
The purpose of CPR 3.4 is the same as its predecessor, Order 18, Rule 19.
Yeah.
Order 18, Rule 19 applied to pleadings and endorsements on writs. These rules enable objectionable material in pleadings to be erased, with the consequence that a judgment on one or more issues may follow. By contrast, where an application to set aside is successful, the relevant order or step in the proceedings is treated as if it had never been made. And in my respectful submission, that is the point. That it is only under CPR 11 that a set aside produces the effect commensurate with a challenge to jurisdiction. That is, that the proceedings are treated as if they had never been made.
Does that mean that if the effect of CPR at 11.1 is that if the appropriate application for a declaration of court has no jurisdiction is not made, if an acknowledgement of service is filed and no CPR 11.1 application for a declaration is filed within 14 days, then the defendant has lost forever the chance to have the claim struck out on the basis that the court has no jurisdiction.
It means that the defendant has submitted to the jurisdiction, and so it can no longer pursue those service defects of which it was complaining. And in fact, it's in paragraph 29 of the decision in Hodinot, but the argument is that any other application, such as a strikeout application or an application to extend time, are implicitly abandoned. That's what 29 Hodinot says.
There are claims issued which are outside the court's jurisdiction for all sorts of reasons. People, counsel don't see many of them, but judges see rather more of them on the papers. People issue nonsensical claims, claims for things that the High Court plainly has no jurisdiction to do. But I think from what you're saying is that CPR 11.1 is so mandatory in its effect that if a nonsensical claim is served of this kind and the defendant acknowledges service, says it intends to defend but doesn't issue a 11.1 application, then it is too late to do anything to strike out the claim on the basis that the court has no jurisdiction.
Or even logically that the court has jurisdiction but shouldn't exercise it, because that's what 11.1b says.
The substantive objections to the claim remain, but the formal objections, for example, that the claim form is only a photocopy, or the claim form doesn't hold a seal, or the claim form was served outside the 4-month period, those kind of objections go if there is no application under 11.1 because of the express waiver which is provided in 11.5.
Well, suppose that we come back to a claim which is not nonsensical, but the claim form is issued, but it's not served until years later. 5 or 10 years later, the claimant produces the claim form, serves it, the defendant files an acknowledgement of service but foolishly doesn't issue the 11.1 application. You say the point about the claim form being years out of time is just too bad.
I do, my lord. And some reason why that might be correct also appears in civil procedure, and it might help if we looked at that passage now. That's at page 142. And this is a point I raised in the permission skeleton, but it comes in here, I would argue.
So sorry, I didn't pick up the page reference.
It's page 142 in Civil Procedure Volume 1, 2023.
Whereabouts on page 142?
If we look together against 3.10.1.
We just read that para to ourselves.
That might be best.
Yes, well, I've read. How does that?
It helps in this way, my lord, because under the system at present, by which I mean that the defendant must use CPR 11 to challenge jurisdiction, there is an established, if I can put it this way, an established system of checks and balances. 3.10 gives the court a general power, but it is firmly established that this power cannot be used to correct away errors such as the late service. However, errors such as these will be weighed if the defendant in question fails to challenge the court's jurisdiction.
Well, I see that is your submission, and it may be right, but it doesn't really explain why it ought to be right.
If the judgment of His Honour Judge Pearce stands, and CPR 3.10 is allowed, to put it crudely, to rescue the defendants in that case, and in any similar case, that system of checks and balances is effectively...
Well, not totally.
...disrupted.
Clearly, you... what happened here is an application was made within the time limit of an application under 11, whatever some rule it is, but didn't specifically invoke Article 11, Rule 11. So that it wouldn't drive a coach and horses if, through what you say is the system of checks and balances, if the error of not invoking Rule 11 was rectified, it would drive a coach and horses if it had been said you can't make an application at all, that you don't need to make an application at all, you can simply rely on 3.10. But that's not what's happened here. This is more like Steele and Mooney.
My lord, I would respectfully disagree with that for a number of reasons. Firstly, that the timing of the defendant's application on the 24th of January, much is made that happens to be within a 14-day period beginning on the 21st. But it's really wholly fortuitous that it was made on that day. And that is the relevance of the letter of the 16th of January, because the letter of the 16th of January appears to suggest that the application was going to be made as soon as possible. And if it had been made on the 17th, 18th or 19th,
Speaking for myself, I absolutely agree it's fortuitous, but it happened. It happened, and therefore the substance of what was happening, namely the point was being taken that the claim form it was too late to issue the claim form, was being made, which is exactly the same substantive point as would have been made in an application under Part 11. Isn't that what matters? Clearly, if it was being sought to be relied on in respect of an application made after the 14 days, your client would have been deprived of something that they were entitled to, namely to know within 14 days whether the point was going to be taken. But it is purely formal, isn't it?
My lord, with respect, with great respect, it isn't purely formal. As I've tried to say, an application to strike out is fundamentally different from an application to set aside.
Well, conceptually, again, I take your point. Conceptually, it is different for the reasons that you helpfully explained and draw attention to what Judge Havelock Allen said. But the result is the same, namely that the action cannot proceed because of the defect in service.
The result may be the same, but given the existence of Part 11 and the fact that it refers expressly to setting aside, many of my learned friends' arguments about reading it as if it was Part 11 or using it instead of Part 11.
Well, these are all respondents' notice points, and I can see why you're slipping into them, but it's not the way the judge decided it. The judge basically just said, I will exercise my power under 310 to treat it as if it had invoked Rule 11 and was seeking to have the service set aside rather than struck out. That's the, I forget whether there's the exact words he used, but that is the substance of the route that he approved. So we don't get into the respondent's notice points if the judge is right about that.
Well, my lords, at the risk of, I hope not repeating myself, there is a little bit more to be said about the use of 3.4. And maybe I'll just complete what I was going to say.
Yes, of course.
About Burns. May I just expand it a little bit in this way? The power to strike out under 3.4 is focused, I would argue, on the content of pleading.
So on the
content of pleadings or content of statements of case. Whereas the power to set aside involves expunging a step from the record. Whilst the consequences may be the same, the purpose of 3.4 is focused towards removing objectionable material in statements of case. What concerns me is that by making an application to strike out, the respondent has recognised statements of case as entities to be struck out. It's inviting the court to recognise the existence of proceedings of which those statements form.
But I see all that, but that is why there is an error that needs rectifying. That doesn't, it's because they have, as you rightly said, chosen the wrong label, and not, you say not just the wrong label, the wrong tool, that they need to get the court to rectify it under 310.
It's a large step. It's not a small step in my submission. It is a very substantial step. It involves, if we imagine the respondent had made the application rather than the judge himself dealing with it, the respondents would have been effectively saying to the court, please remove, strike out my strikeout, to be facetious. Remove my strikeout.
Yes.
And in its place, substitute an application under Part 11. It is a major step. And
is it a major step of a kind which 310 can't do?
It can't do, as I've said in the skeleton, without considering the Denton principle.
Well, we'll get to that. We'll get to that one step at a time. The point I'm putting to you, not expressing a concluded view, is that although there is a certainly clear circumstances in which you can't use 310, the Venos,
yes,
that's really where doing so would deprive the other party of particular safeguards which the relevant code gives them.
yes.
certain criteria under which, certain restrictive criteria under which the applicant can get relief and so on, which would all be bypassed. This is a case I'm putting to you where there isn't any problem of that sort. All that's been happened is a wrong, and I perfectly accept completely wrong, procedure, nevertheless seeking the same result and relying on the same grounds, seeking the same substantive result and relying on the same grounds, has been used. And if subject to discretionary considerations, 310 is perfectly capable of covering, rectifying an error of that kind, isn't it?
But the appellants have been prejudiced, because if that step wasn't taken, they have the benefit of the statutory waiver.
That's true, but I mean, the defendants are always prejudiced by the exercise, or the other parties always prejudiced by the exercise of a power under 310, because the procedural, take Steele and Mooney. If the power to rectify hadn't been used, the action would have fallen.
There was a discrete error in the consent order in that case, where it was fairly easy to use the second part of 3.10 to correct. This is, I would respectfully argue, is very different. We've already established the differences between strikeout and setting aside. A major substitution exercise would result from the judge's order. And it involves, as I've tried to argue, bypassing or circumventing the machinery in Part 11. Learned friend tries to suggest in his skeleton that the judge was in fact upholding Part 11, but he wasn't doing that. He was deeming the whole machinery of Part 11 to have been operated simply because a different application happened to have been made within a 14-day period.
Well, it's not a completely different application. I absolutely take your point that it's an application to set aside, which conceptually involves that the court had jurisdiction. Sorry, it's an application to strike out, which conceptually assumes that the court had jurisdiction. But substantively, it is the same application. It's effectively to say that the action cannot proceed because the claim form is not issued in time. Sorry, the claim form is not served in time.
My lord, that it still raises a question mark about how a court should use a wide catch-all power of the type in 3.10. Yeah. As I've said, a claimant does not have the benefit of that provision in relation to originating process. To allow a defendant the benefit of that provision on the other side of the coin in relation to Part 11 ignores the position of claimants, but it does in effect circumvent Part 11, and I would argue contradicts a principle that emerges from ideal and from Peanuts.
That's very helpful and clear. I'm not going to sort of bash on at you about it. I have to think about it, but just one further point. You were referring to the cases about originating process, but one thing that you might be said that emerges from Barton is that originating process for particular reasons it has a special status as a rule, which it's very difficult to get around, and that is reflected in the particular rules, 615 or whether it's 615 or 75 or 763. There's no real analogy here under Part 11, is there?
My lord,
I put that challengingly, but what I mean is there a real analogy?
what I said about that in the skeleton is that the way to look at it is that Part 11 is the other side of the coin. It's how the defendant views originating process. And in that sense, it is sufficiently connected with originating process, such that a similar approach applies. However, we look at it, whether as a subcode or otherwise, Part 11 is, if I can put it this way, still intimately connected with originating process.
Yeah.
And a similar level of scrupulousness is required applying 3.10 to Part 11 as it is to 7.6, 615 and 616.
But why? I mean, is that a general proposition, or is there something special about 11.1?
My Lord, I think we can read that the draft must have intended something special because, as I've said, the provision contains an express warranty, otherwise a sort of warranty, express waiver that is created on the face of the order in 11.5. It is slightly unusual, I would argue, to see in a procedural rule that a party is to be treated in such a way, as 11.5 says. I would argue that gives to 11 an equivalent status as regards a defendant as the rules about originating process are for a claimant.
Yes, sorry, we've rather taken you out of your course, though I rather suspect that in doing so we have covered the points you really needed to make under Ground 1.
My Lords, I suspect that is correct. I obviously wanted to say something about Denton.
Oh yes, well that's Round 2. You've sort of got 3 rounds to go, though I don't think the others will take so long.
No. Well, may I turn in those circumstances to paragraph 27 of the skeleton? The argument is, the ground is that to treat the respondent's application notice as equivalent to including an application for a declaration that the court has no jurisdiction, the court should have had regard to the principles in Denton and White in 2014. This has provoked a dispute between my learned friend and I about how a passage in the White Book should be interpreted, and that passage
It's a bad sign.
It's bad, isn't it? Yes.
I think I speak for all 3 of us in saying that we don't regard passages in the White Book as authoritative.
No. However, there are some important matters that can be extracted, I believe. In fact, we're back at page 142 in the current one. Essentially, if I can put it this way, the battle line between myself and my learned friend is that my learned friend is saying that as regards this passage, all that judge...
Just show us where the passage is.
It begins at 3.10.3 in the bottom half of page...
The bottom half of the first paragraph.
Or bottom half of page 142.
No, but I thought the passage is the one that starts the bottom half of the first paragraph under 3.10.3. Is that right?
Yes.
There are 3 possible lines.
There are 3 possible lines, exactly, yes.
Let me just remind myself exactly what that says. I know it's in your skeleton. Yeah, thank you.
My learned friend says that all the learned judge was doing was remedying an error, and therefore what he did fell within subparagraphs Roman 2 and Roman 3. I argue that no, the judge was going further and invalidating, and in a moment I'll say why I argue that. But before I get there, if we take what is said in the White Book at face value, I wonder, in fact, whether there is any difference between us, because if we look together at the second paragraph, beginning an order under 3.10, and go down in that paragraph about 7 lines, we get to a sentence that says, thus save as I explained below, when considering whether to invalidate, correct or waive any irregularity, in other words, all 3, the court might first consider whether the procedure error in question was serious or significant, then consider why the error occurred. So I asked rhetorically, first of all, does this dispute actually matter? Because on one reading, whether it's invalidation, correct or waiving, the authors seem to think the real question is whether the error was serious or significant. And I would answer that point by saying, well, to attempt to strike out when you really meant to operate Part 11 is fairly obviously a serious and significant error. And so if I'm right about that, then the panoply of Denton principles...
I think you shouldn't assume that that is self-evident, that first step. I can obviously see, I see why you say that it's serious in one sense, in that the wrong route the wrong route has been adopted. It might be said to be not serious because it's purely formal and everyone knew what in practice the issue was that had to be resolved.
Well, as we've already debated, I don't want to open up the debate again. Is it purely formal? I would respectfully question that. But if we look at the language at 142, ask ourselves, well, let's imagine the respondent had made an application under 3.10. What would the respondent have been asking the court to do? The starting point in 3.10a is that the error does not invalidate any step in the proceeding. But here, the respondent would have been saying to the court, whilst my application refers to 3.4, it is invalid because it should have referred to Part 11. So please replace it with an application under Part 11. In other words, as I've already said, please, at the risk of being facetious, please strike out my strikeout. In that process, had the court acceded to the respondent's application, there would have been nothing left of the original strikeout application. It would have been invalidated and replaced with something else, something different.
Have I got this right, Mr. Trotman? Hill Dickinson did 2 things wrong. First of all, they didn't put a tick in the 3rd box on page whatever it is. Secondly, they applied for an order striking out the claim, whereas they should have applied for an order for a declaration that the court had no jurisdiction to try the claim. Those are the 2 mistakes.
Those are the 2 mistakes.
And you say that that's serious and significant error because there's a fundamental difference between the court declaring that it has no jurisdiction and the court striking out the claim.
Respectfully, yes, that is what I would say.
Thank you.
And just to be pedantic, but because this point I think is made by the judge himself, the first of the 2 errors, though undoubtedly was an error, isn't really the error that matters, because even if you don't tick the box on the claim form, rather oddly. I mean, the whole thing's odd. So if you don't tick the box on the acknowledgement of service, if you nevertheless within 14 days
Yes.
Do serve an application under 11, whatever it is, that's all right.
My lord, if I can say
Neither
something,
necessary nor sufficient, I think the judge says.
if I can say something about that, the best way to analyse the box ticking point is this: if my learned friend wants to say that, that because of accompanying or covering correspondence, the respondent's position was, in inverted commas, always clear, my response to that is, well, the correspondence point isn't a good one because you tick the wrong box on the acknowledgement of service. I think that is really as far as the box ticking point goes. I accept that. But the fundamental point is the second point that
Yes.
my Lord made. But in order to ask the court to to deal with that point, my argument is that that invalidation is required, and that effectively, because the respondent is asking for one tool, as the Lordship has said, to be replaced with another, that is asking for invalidation, and it triggers the principle in Welsham, which is well established, and I perhaps don't need to go through the facts of Welsham. We can simply look at the relevant passage at page 182 in the final authorities bundle. The issue in summary in Welsham was a application to strike out because of failure to comply with directions about disclosure. And the defendant appealed unsuccessfully to the Court of Appeal, trying to argue that there should have been a strikeout on the basis of Denton. But the important passage, as I say, is at the top of page 182 in paragraph 44. The judge treated the principles in Mitchell as relevant and important, even though the question in this case was whether to impose the sanction of a strikeout for non-compliance with a court order, not whether to grant relief under CPR Rule 3.9 from an existing sanction. In my judgment, that was the correct approach. The factors referred to in Rule 3.9, including in particular the need to enforce compliance with court orders, are reflected in the overriding objective in Rule 1.1. to which the court must seek to give effect in exercising its power in relation to an application under Rule 3.4 to strike out for non-compliance with a court order. Even if I'm wrong about that, it's impossible to treat or construe the respondent's application of 24th January as one under CPR 11, and so such an application is yet to be made, and such an application would require an extension of time, which would invoke the guidance in Denton. And so through either of those routes, I do, with great respect, criticise the learned judge for not dealing with the
Would you accept this proposition that even in cases under 3.9, which is where Denton was originally devised for, but a fortiori in cases where it's applied, as it were, by analogy, like Walsham,
Yes.
we're concerned with substance, not form.
Yes.
You don't have religiously, it's better because it enables you to think in a disciplined way, but you don't have to go step by step through the 3 stages, and very often they all tend to meld into one anyway. So really what we ought to be looking at ultimately, which you do in your skeleton argument, is simply whether the general discretionary factors,
Yes.
which were relevant in the circumstances of this case, were properly taken into account by the judge. Whether or not he used a Denton label for them or a Denton structure for them or not.
My lord, yes. My principal concern in this area of the case is the fact that, as we know, Denton focuses attention on the procedural behaviour of the applicant. And the applicant here must have been the respondent.
Yeah.
And it's of concern, I would argue, that instead the learned judge focuses attention on the procedural conduct.
Well, that's really ground 3, isn't it? Personally, I think, I may be wrong, which I think there's an element of shadow boxing about whether or not Denton should have been applied as such. Your real substantive complaint is that the focus was taken off why the respondents made the mistake they did.
Yes.
And put onto the errors which relating to the claim form.
Yes.
And that's I think that is, doesn't matter, it's ground, I think that is your ground 3.
Yes.
As to that, what I think Mr. Ray says, and certainly what struck me reading the judgment, is that quite what the judge was doing? The judge was meeting a point being made by you, I think. What sauce for the goose is sauce for the gander. The court has taken a strict approach to our errors. It ought to take an equally strict approach to the defendant's errors. And it was in that context that the judge carried out his comparative exercise. Have I got that right?
My lord, in essence, yes. But I am respectfully concerned about the process employed by the judge. True it is, he did acknowledge the contrary arguments, I think at paragraph 72 of his decision. But he should at the very least have heard argument about the merits and the implications of the respective merits for the 2 points he'd set himself at paragraph 72. I think if we
Did he actually say he was not prepared to hear argument?
Well, at the beginning of the hearing, I attempted to raise some of the procedural points, but at that stage the judge said he didn't want to deal with them, and he wanted to proceed straight to argument about CPR.
Just remind me, you set this out in yourself as an argument, do you?
Part 11, yes.
Just read the paragraph.
Yes, it's paragraph 43, I think.
Thank you.
Court did not at the hearing on allow argument on procedural merits, although the appellants attempted to review them at the start of oral submissions.
Where are you reading from?
That's should be paragraph 43.
Yes, but there's 43's got various sub-paragraphs.
Oh, so it's Roman 5, sorry.
I think it's 2 actually.
Sorry,
43 Roman numeral 2, Mr. Trotman.
Yes, sorry.
Yes, sorry, yes.
It was so significant to the valid points the learned judge had raised at paragraph 72 that, as I say, he should have heard argument about the matters that he set out in paragraph 73. I think my learned friend might respond to that by saying, well, there hadn't been an appeal against that part of District Judge Matharu's order where she made conclusions about the claimant's conduct. That's a fair point, but the learned judge had said that he was embarking on what he called a new exercise of discretion. And if he was going to do that, then going into that new territory, not having invited any submissions at all from counsel on that point, my argument is that in fact, if he then goes on to raise merits in the way that he has done, he ought to have heard argument from counsel about those merits.
This is procedural merits, surely.
Yes,
I mean,
yes, I'm sorry, yes.
Speaking for myself, I was rather alarmed by your suggestion in your paragraph 45 that the judge made an error of law in not considering the substantive merits.
Yes, I possibly went a little far there.
Right, okay. I know nothing about the substantive merits.
No.
Just proceeding on the basis that the claimants may well have a case and the defendants may have a defence.
It's not appropriate to look at those at this stage. I think that is respectfully correct. But the procedural merits are another matter. And it would have been possible to make points of the kind which I've set out in 43 Roman 2, and the appellants didn't have the chance to do that. And had the issues embraced...
I suppose I ought to just briefly explore this. You did presumably make submissions, well, I think it's clear from the judge's saying, of what I call the source for the goose, source for the gander type. You've been strict with them.
Yes.
Or Judge Matharu was strict with them. And you should therefore be strict. You should be strict with us, therefore you should be strict with them. I mean, surely it would have been open to you then to say, because really what we did, of course, we're bound by Judge Matharu's decision that we don't qualify for the relief under whichever it is, 7 or 8 extension.
Yes.
It wasn't as bad as it looks. The judge said, I'm not going to hear you on that. Or was it really, you say, the path was set by how he approached it at the beginning?
It was set by the way in which he approached it at the beginning, and as I say, in fairness to the learned judge, neither I nor my learned friend had any idea that he was going to raise 3.10. It sounds critical, but he did not intimate that point at all during the hearing on the 24th of May.
Oh, I hadn't picked that up. I'm bound to say, I'm sorry if I... You're saying that 310 is something that the judge not only thought of for himself, but thought of for himself after the hearing was over.
The matters in paragraph 70 onwards are matters that were not the subject of oral debate or oral submission. They came entirely from His Honour Judge Pearce. And that's why he called it a new exercise of discretion.
But he would have said that anyway, even if, because it was formally, it is a new exercise of discretion, because the district judge hadn't done it. Well, I'm embarrassed if that you make that point in your cell, didn't you? I obviously just skipped over it.
Actually, I criticise myself. I didn't make that point in the skeleton, but I suppose because I thought it was so obvious. But that's my error. But it is the case.
But wait a minute. I mean, you were given permission to appeal to the circuit judge on a single ground. And then we have skeleton arguments where, I'm just looking first time at Mr. Ray's skeleton in the court below, seems to me to travel across a good deal of the ground that's the subject of debate here. Is Hoddinott binding? Was it ever? Reference to some, though not all, of the cases that we've been looking at. Reference to Lord Sumption in the Wright Hassel case, and arguing that if an application is needed under CPR Part 11, the respondent's application should have been treated as just such an application. Alternatively, if it can't, then Hoddinott must be limited to its facts. It didn't involve an application to strike out, and that an application to strike out is nonetheless a valid route. I mean, that may or may not be wrong, but does the failure to refer expressly to Rule 310 add much to that?
My Lord, I would argue that, respectfully, it does, and for this reason, that in all of the respondents' documents, there had been, perhaps one wouldn't credit, there's been a studious avoidance of conceding that any kind of error had been made. The respondents' expressed position at leading up to the hearing before Judge Pearce was that it was perfectly acceptable to use 3.4, and if the court had an issue with that, then there were various ways in which the same result could be achieved by treating it as an application under 11 or simply using 3.4 in place of 11. But it had never been acknowledged that that was an error. And the novelty in this case is that without hearing submission, the learned judge decided to put it in the category of error and apply 3.10 to it.
I don't want to be critical, but I better say this as it's going through my head. I would have expected, if the circuit judge decides a case on a argument of law not raised before them, I would normally expect to see that's a ground of appeal, procedural unfairness. Maybe that's not how you're putting it, but
well, I did effectively raise that argument in the grounds of appeal, in the sense that the complaint was made about the merits, and so I would argue that I did deal with that.
But anyway, there it is. For better or worse, you say, no reason to doubt it, and Mr. Ray contradicts it, that it happened as you said.
Well, look, I would have some slight contradictions to that.
Yes, I see. Well, we better hear you about those
Now or
if it arises. Well, I think you're probably nearly the end of your submissions, aren't you, Mr. Not quite, but nearly.
Well, my Lord, I think all I'd like to do is just, if we have my skeleton open,
Yes.
and we can pick it up around about paragraph 31. We've got onto Denton. I've said at 27 the court should have considered the Denton criteria. At paragraph 30, I've argued why, in more detail, Denton is retracted. I've referred to Walsham at 33. What I haven't so far addressed the court on, and I don't propose now to address it in any great detail, are two grounds in relation to Denton, beginning at 37, promptness and knowledge. I still argue in paragraph 38 that the respondent requires an extension of time to make its 11.4 application, and if that's right, falls foul of well-known authorities in the Denton field, such as British Gas Trading and Oak Cash and Dirier and Bajaj. And I say that knowledge, although subject to analysis in Barton, looked at through what I've called the lens of Denton, becomes extremely important. And when one is applying Denton, it is relevant, but because of the letter in late November 2019, the defendant did have full knowledge, the respondent did have full knowledge of the claim. If the appeal is allowed, and the respondent being deprived of an accrued limitation defence is not a factor militating against the appeal or unhelpful to the appellant. The respondent was aware of the appellant's, this is paragraph 41, the respondent was aware of the appellant's attempt to serve on the 27th of November. The acquisition of the limitation defence would therefore, I argue, be a windfall to the respondent in those circumstances. And then we've already discussed ground 3, 42, 43. In relation to ground 5, the gist of it is the case of Burns-Anderson, and I've already addressed the court on that. And I've dealt with some of the what I call logical difficulties, the logical implications of 3.4 in paragraph 47 of the skeleton. And so I think, subject to addressing some of the points learned friend makes about Hodinoff and Kane, that probably brings my submissions to a close.
Thank you. You haven't formally, but I think this may be deliberate, and even if it isn't, it's probably the right course, addressed the respondent's notice, although some of the points have effectively come up in the course of what you have been submitting.
Yes.
But I think we probably think that's better dealt with in reply so far as necessary.
I would reserve the right to reply to the learned friend if I could.
Well, you will have the right to reply if you...
I apologise for writing this stage. The only thing I would say about that is that my learned friend has had the benefit of seeing what I say in response to his grounds of appeal in my skeleton argument. Because of the sequential nature of things, I don't have any idea, beyond insofar as it's been covered thus far, what he says in reply to my grounds of response.
Yes.
Which means that it rather limits what I can say. Effectively, when he makes his points, those will be after me. That will be the first time that those points are made. And unless I have anticipated them, I won't have had anything to say about them.
Well, I think what we're going to do is rise and just see where we are. Unless either my lord or my lady would like to ask anything before we do that. Yeah, why not? Yes.
Can I just ask about one point made at the end of your skeleton argument?
Yes.
You're answering the suggestion that the respondent's strikeout application should have been construed as one made under CPR Part 11.
Yes.
I can't remember whether that was something covered by Judge Pearce, but it seems to me that it's a point you might like to deal with now, because it's almost part of the main argument on the appeal.
Yes. First of all, as to whether Judge Pearce dealt with this point, I believe that it was the last of the points that he dealt with. I think this was the point that he dealt with at paragraph 69, at page 127 of the core bundle. And in fact, this does lead us to the case of Kane and Advertiser, which my learned friend focuses quite a lot on. As he says, it might help him if I gave my response to Kane and Advertiser and the points he makes about the case. If we...
That's Mr. Justice Dingman's decision.
Dingman's, yes. If we look together at Kane, we can find it at 253 of the final authority bundle. And in that case, the claim form was issued. This was a defamation case. The claim form was issued in May 2017. Out of time, it was delivered on the 5th of October 2017 by hand without a response pack. On the 19th of October 2017, the defendant emailed an acknowledgement of service, not ticking the intent to contest jurisdiction. On the same day, there was a covering email taking issue about the correct service of the claim form. On the 26th of October, the defendant's solicitors noted that the claim form had not been served within 4 months of issue. 3rd of November was 14 days after filing the acknowledgement of service, and 7th of November was the defendant's application to strike out under 3.4 or 24.2 for failure to serve the claim form within time. In May of the following year, written submissions of the claimant took the point that the defendant had not disputed jurisdiction within 14 days under Part 11. However, in this case, on the 18th of May, the defendant applied retrospectively for a 4-day extension of time to file the 11.4 application from 3rd November to 7th November, but also applied for relief from sanction that it should not be treated as having accepted jurisdiction. And that is the language the defendant's solicitors used in their witness statement, referring to implicit sanction in Part 11. The matter was first determined by Master Yoxall, and his thinking has been summarised by Mr. Justice Dingman's at paragraph 18 on page 257. Master Yoxall addressed Mr. Kane's arguments that the challenge to serve could only be made under Part 11. He referred to the judgment in Hodinot together with Actas Nadepta and Burns Anderson. He noted that in Actas, Lord Justice Ricks had said that Part 3.4 applied in terms to a statement of the case rather than to a claim form, and recorded that as a difficulty with the proposition that 3.4 was the correct route for striking out a claim form. Master Yoxall then set out part of the judgment in Actas and went on to hold that a defendant is entitled to strike out a claim form served out of time under 3.42 in paragraph 30 of the judgment. Having held that the judgment in Actas was obiter on this point and wrong, because it had overlooked CPR Part 2.31. Master Yoxall, paragraph 19, considered Burns and held that the conclusion about CPR Part 11 applying was wrong. Master Yoxall concluded in paragraph 33 that a defendant could use either CPR Part 3.4 or Part 11. With that background, Mr. Justice Dingemans then set himself a number of questions, which we can see on the following page at 258 in paragraph 22. Whether advertiser, the defendant, had chosen the wrong procedural route by applying to strike out, and was Master Yoxall wrong both to treat the application to strike out as an application under Part 11 and to extend time. The conclusions Mr. Justice Dingemans came to can be seen at paragraph 28 on page 260 and paragraph 30 on page 261. Paragraph 28 is essentially a summary of Hodinot, and I don't propose to read it out. The key paragraph is really paragraph 30 on 261 and also 33 on 262. In these circumstances, in my judgment, the decision in Hodinot followed in this respect by...
Well, can we not, this we can take shortly. This isn't on the particular point, is it? I mean, this is on the point we've already looked at. It agrees with you that Hodinot says that 11 is the only route.
My Lord...
Am I missing?
But then 31 to 33 goes on.
Oh yes, absolutely. That's.
Yes.
I'm just saying 30.
Can I deal with 30 because
yeah, all right. Yes.
I want to meet a point that my learned friend makes in his skeleton.
Sorry, carry on.
Yes, my learned friend's point. I hope I do him justice. Is that Mr. Justice Dingemans himself wrongly applied Hodinot in this case and may have been himself influenced by the mistake which the court made in actas and adepta. With respect to my learned friend, I cannot see that. It is clear that Master Yoxall also understood that a mistake had been made in actas and adepta, but it was Master Yoxall's error, having noted that mistake, to say, well, in fact, 3.4 can still be used to strike out a claim form.
Yeah.
Mr. Justice Dingemans did not fall into the same error, and we can see that in paragraph 30 itself. 4 lines in, Master Yoxall was right to note that in the analysis in actas, the courts appeared to overlook the provision of part 2.3 relating to whether a claim form was also a statement of the case. And these are the critical words. But this does not meet the point that Hodinot versus Persimmon was binding. So there's no error by Mr. Justice Dingemans. He's not misunderstood Hodinot. He's not misunderstood actas. He makes, with respect, a perfectly valid point about Hodinot. So I defend what he has said in Kane. The next point is the one that the Lordship has just mentioned, whether you can treat the application as being made pursuant to Part 11, and again, I'm not going to read all of 32. We can pick it up at 33, at the top of page 262. The application made on the 7th of November raised points about late service, but was not an application under Part 11. However, by 18th of May 2018, in the light of Mr. Kane taking the CPR Part 11 point in his submissions filed after the first hearing before Master Yoxall, the point about Part 11 was expressly addressed, together with an application of extension of time. In the application dated 18th May 2018, there was express reference to an application under CPR Part 11 and for an extension of time. In the supporting witness statement, reasons were set out for relief from sanction implicit in Part 11. In these circumstances, I am satisfied, and these are the important words, the joint effect of the applications of 7th November and 18th of May is that an application was made pursuant to Part 11. In other words, there were very special circumstances which applied on the facts of Kane. An express application for a retrospective extension of time had been made referring to Part 11. And so on those particular facts, Mr. Justice Dingeman was entitled to come to the conclusion that the joint effect of the applications was that an application had been made pursuant to Part 11. My learned friend in his skeleton suggests that it was only because the application in fact made in Kane was out of time that it was necessary to make an application under Part 11. I respectfully disagree. It was always independently necessary for the defendant to make an application under Part 11. It just so happens that, to put it in a rather crude way, that the penny dropped with the defendant and it did decide to make an application under Part 11.
When was Part 11 first referred to by either side in the present case?
Well, in the present case, my learned friend complains that Part 11 did not appear as an issue, I think, until 3 or 4 days before the hearing before District Judge Matharu in August 2021. I'm not sure, with respect, that's a particularly good point for
I was only asking when.
Sorry, I'm sorry.
Not why.
Sorry, but yes, that is when it.
3 or 4 days before the hearing before.
I think that's mentioned somewhere in
Yes.
the Pearce's judgment. Isn't it? Yeah.
Yes.
So really what happened in this case is that an application was made belatedly under Article 11, probably Article 11, that's my employment law background, under Rule 11, together with an extension. The extension was granted, and Mr. Justice Dingeman's and therefore, as it were, relief was granted under Part 11 by Master Yotzel, and that was upheld. To be more accurate, I think Master Yotzel did it in the alternative, didn't he? He said if he was wrong about the effect of Hodinot and the use of Rule 11 was mandatory, then he would grant the extension. I've got that right, haven't I? It's para 20. And that's approved by Mr. Justice Dingeman.
Yes.
So this was a more elaborate route.
Yes.
And you say it's the route that should have been followed in this case.
Yes.
Rather than taking the shortcut of simply using 310.
Respectfully, yes. Yes.
Though it comes to very much the same thing.
Could I just show the court, perhaps the best way is to show the court what my learned friend says about this case at 24 and 25 of his skeleton, because I don't think I've really done justice to his arguments. So the court is aware of what's being said. This is at page 82 of the core bundle. What my learned friend is saying is that Mr. Justice Dingeman was influenced by actas and adept. Sorry,
This is the point you've already dealt with.
Because in ACTAS, the court had rejected submissions that the application could be made under 3.4. He's saying at paragraph 25 that the High Court in Kane was wrong to hold that it was bound by precedent to find that an application cannot be sold.
Well, I think you introduced us to that point perfectly fairly.
Thank you. So that's my response to the point about construing as Part 11. My learned friend also relies on some cases that equate 3.4 with summary judgment under Part 24 and tries to say that because judges have contemplated an overlap between those two provisions, he should be allowed to have an overlap between 3.4 and Part 11. However, I submit it is considerably more complex than that, and in the latest authority on that topic, in Said and Ibrahim in 2018, the Chief Master Marsh, I think, was very scrupulous, in fact, about equating the two provisions.
Well, it would be a pity if this case turned on the resolution to a distinct debate.
Yes.
Anything else, Mr. Dodd?
No, my lord, I made the points I wished to make.
Right. Well, we will consider the position over the short adjournment and see where we've got to. I'll sit again at 2:00.
Right.